I'm going to go ahead and get our conversation starting. Good afternoon, everybody. My name is Sarah Appel, and I am the director for MSARA. And our headquarters are located in Minneapolis, Minnesota. Probably heard us talking about snow a little bit earlier. We all know that professional licensure can be quite confusing, and we need some help navigating it. So I am very happy to let you know that we have help on this topic today. So I'm very happy that Higher Education Licensure Pros are with us, and I am going to turn it over to Nan and Chris, and Nan, I will let you do the introductions. Before I stop, I just want to let folks know that this session is recorded, and we will have the slide deck and the recording up shortly post-event. Thank you so much.
Great. Thank you, Sarah. We are so glad to be here. And as Sarah mentioned, really grateful for all of your patience as we had to redo this session we were supposed to have a couple of weeks ago. So appreciate your patience here and for being able to show up today and participate. So if you don't know me, my name's Chris Mall. I've been working in professional and occupational licensure compliance issues for over 15 years in higher education. I spent a large portion of that time working for Capella University, which is a large online institution headquartered in Minnesota. That is where I got to meet Nan and how we became acquainted. So about 3 years ago, we formed Higher Education Licensure Pros, and the purpose is to support institutions with compliance related to professional and occupational licensure, in particular the Title IV regulations that went into effect July 1, 2020 around disclosures. And as you all are well aware, we've got changes coming for this July 1st, which we're going to dig into shortly. But first, I'll let Nan introduce herself to you all.
Thanks, Chris. Hi, everyone. Yes, I worked at Capella University from 2010 to 2020 and met Chris there. I worked across schools at first, helping them gain specialized accreditation, and then exclusively in the School of Counseling, providing operational support to many of their units and helping them to continue to meet quality assurance standards. Prior to Capella, I worked at the University of Minnesota, primarily in the School of Social Work, and also obtained my PhD from there. Learning all about licensure research the last 3 years and some months, and happy to be here with you today. Back to you, Chris.
Great. So we have an agenda. Here's what we're planning with our time together. I'm going to do an overview of those Title IV regulations, in particular with the upcoming July 1 changes, and then some notes about SARA policy as that's applicable. We'll have plenty of time for your questions, so feel free to put questions in the chat as I'm talking. You can also be prepared to come on to video or audio to ask your questions when we get to that questions portion. What we're also planning to have discussion later today. So we do have an hour and a half booked. Hopefully you can join us for the whole time. And really the last 20 plus 30 minutes-ish, we want to have discussion with you all. So talk more specifically about how implementation is going, what your plans are at your institution, things that you're considering, even getting really into the weeds on some of those issues like the student location policy and written attestations, that type of thing. So you can start thinking about that in the back of your mind too throughout our presentation so that you're ready for discussion when we get to that. We really appreciate it. Just real quick, you noted on the slide, but this is not legal advice today. So I am an attorney, but I am not your attorney. And you will hear things, myself and others will say, I'm sure that it's definitely important to have legal counsel on many of these issues because they are important and there is obviously quite a bit of risk around making these decisions and putting plans and processes into place. All right, so let me start with that overview. What is required? What are the responsibilities for institutions under federal Title IV regulations and SARA policy? When we talk about this, we kind of break it down into three primary responsibilities that institutions have. The first is you need to understand if your licensure programs meet educational requirements in other states and territories. Nebraska should be the easy one. I think probably most of you can say confidently, your programs meet Nebraska's requirements. So really the focus is on those other states and territories where you will be enrolling students and recruiting and advertising. The second responsibility is around certifying or certification. And this is the new program participation agreement certification responsibility that's starting this July 1st. And I'm going to get into way more details on that here in a moment. The third main responsibility is around communicating. And this is the one that's a carryover from current responsibilities or requirements under those July 1st, 2020 Title IV regulations. So not very much has changed around the communicating responsibility with public and direct disclosures, but I will get into some detail on that here shortly as well. So let's dive into that first responsibility, understanding if your programs meet those educational requirements for licensure in each state and territory where you're recruiting for students for that program, advertising that licensure program, and most importantly, enrolling students. Licensure programs, what does that mean? So first, a quick note about licensure. That is kind of our umbrella overall term that we're using to refer to a group of things that can be called lots of different names, again, depending on the state or territory. So it might be called a certification, a certificate, an endorsement, an authorization, a registration. Really, it's shorthand for any type of credential that's issued by a state or territory government entity that's required for employment in that profession or occupation. So if you see licensure, just keep in mind that could be called something else depending on the profession or occupation or the state or territory. And so what is a licensure program then, right? The Department of Education has not provided any sort of list for what they consider licensure programs. They don't even really provide a lot of clear direction on this, but we do have some information from their commentary released with the 2020 regulations, along with a commentary released with these new July 1, 2024 regulations. So basically, a licensure program is something that your institution has designed to lead to one of these professional or occupational licenses, or that you're advertising as leading to that. So again, we don't have a nice clean list that's provided by Department of Ed or anyone else. We're actually not aware of one comprehensive list that has every single license available in any state or territory, but there are some resources to help get you started. So we can point you in the direction of those if you're stuck at that point, trying to figure out what your licensure programs even are, because that's an important first consideration. So you have to understand, once you know what your licensure programs are, understand if they meet those educational requirements. And I wanted to make a quick note here about the recruiting, advertising, and enrolling. Some of you might be wondering, well, I didn't see anything in these regulations about recruiting or advertising. You are correct. That is not in the regulatory language itself. So it wasn't part of this new July 1, 2024 regulation that the department released. However, myself and other people who have been asking questions to Department of Education staff have consistently been getting information from them that their expectation is institutions are only advertising and recruiting for programs where they know that their program meets the educational requirements. So again, it's kind of narrowing down maybe a list of states and territories where you need to have this understanding about if your program works or doesn't, but you want to make sure that you're factoring in this recruiting or advertising for that licensure program as part of your considerations here. Okay, first bullet point. This does apply to all types of program, all modes of delivery. I know we continue to hear some confusion that this is only applicable to distance education programs. That is not true. It is applicable to any type of program. Again, that's a licensure program that your institution is offering. There is a connection with distance education in the new PPA certification section of the regulation, and I'll get to that in a moment here. But just keep in mind, these requirements, the understanding responsibility does apply to all modes of delivery of your program. And again, you need to have an understanding if your program meets or doesn't meet educational requirements in other US states and territories. Often today, when we talk to institutions, they've not determined if their program meets or doesn't meet in some or even in many states and territories. That's because under the July 1, 2020 version, the disclosure requirements, Department of Education had this kind of third category of not determined or no determination made that was explicitly spelled out and required in the public disclosures under these current regulations. But that is changed under the July 1, 2024 requirements, which I'll get into here in a moment under disclosures. So the understanding piece, right? You still may have many states and territories where you've not determined yet if your program meets or doesn't meet. You will likely need to make a determination before July 1st for other states and territories. Again, if you have students or prospective students located there where you're going to be potentially enrolling them, or if you're doing direct recruiting or advertising for that licensure program, you will need to make that determination and move them out of a not determined kind of category. Thanks, Nan. So I'm going to move to the certify responsibility. Again, this is the new responsibility starting this July 1st. Again, it's applying to all types of programs that are licensure programs offered by institutions. And this is connected to the program participation agreement. The PPA is basically the master contract that every institution has to sign with the US Department of Education in order to participate in the Title IV program. So your federal financial aid, you have to agree to the PPA in order to do that. The PPA has been around for a very long time, and it continues to be added to or modified over time with these different terms and conditions or things that you're agreeing to as an institution. So what Department of Education did is they added this new condition that you have to be able to certify that your programs meet the educational requirements for the state where the institution is located and where your students are located at the time of initial enrollment in the licensure program. There is an exception that the department put in here. You could potentially enroll a student who's located in a state or territory where you do not meet the educational requirements or you've not determined yet. They would need to complete a written attestation that clearly indicates they plan to be licensed and employed in a particular MEETS location, a MEET state or territory after they complete your program. So that's the exception here, this written attestation. And we can dig in more into that as well throughout our time together today. So I mentioned distance education before, right? And there's kind of still, I think, confusion around these requirements only apply to distance education programs. In reality, they apply to all modalities of programs. I think where the confusion stems is because if you look at the regulation language itself for this new PPA certification responsibility, which by the way, we have all of the actual language in kind of resource slides at the end of the presentation. So you'll have that available to you if you haven't seen that before. But what that language says is that institutions must certify where the institution is located and where students enrolled in distance education are located at the time of initial enrollment. So the messy thing about this is the definition that Department of Education staff are indicating applies to distance education is one that was put forth in a May 2023 Dear Colleague letter that says if a student is enrolled in one or more class that's through distance education, online specifically is how department staff have been framing it. If they're enrolled in one or more online class during that first term of enrollment in the licensure program, then they should be considered distance education. So again, we can dig more into that if people have questions, but that's why when I talk about this generally, I think it's important to note that it's really going to be about where any of your students are located. Many of your students are going to be located in Nebraska, probably based on how you determine their location, which is the other point I was going to make on this slide briefly is around student location policy. So under the current July 1, 2020 requirements, some of you might remember or recall, be familiar, each institution sets their own student location policy and processes for determining student location. Well, the Department of Ed has retained that same structure under these July 1 changes. So every institution should have a student location policy in place that you're using to apply for these circumstances. So for the purposes of PPA certification, and disclosures related to licensure programs. That student location policy will look different from institution to institution, and that's going to depend on a number of factors, including the types of programs you're offering, your geographic location, like if you're near a state border or not, if you have commuter students coming across the state line or not, and then really just how many licensure programs we're talking about and what the makeup of those are. Those are some of the considerations that will dictate differences potentially in student location policies for different institutions. And we do have some examples available of student location policies, as well as that written attestation exemption or exception that I mentioned. And again, you'll have access to those after today when the materials are available. All right, so moving on to that third responsibility for institutions is around communicating this information. So as I mentioned before, not much has changed from the 2020 version to this year's version around public and direct disclosures. The most notable change is with public disclosures. So Department of Ed has removed that not determined or no determination made category from the public disclosures. So institutions are no longer required to publicly disclose on your website or otherwise that you haven't determined certain states if your programs meet or don't meet. What the new regulation does say, so starting this July 1, every institution will have to disclose publicly where they've determined that the program meets educational requirements for licensure and where the program does not meet those educational requirements for licensure. Some institutions may choose to continue disclosing those not determined states or territories. If you have some, that would be fine. There's nothing in the regulation that prevents you from doing that. They've just removed that requirement as part of the 2024 version. So with public disclosures, some institutions are going to need to disclose for really all 59 US states and territories still. So again, if you're going to be enrolling students that are located in one of those states or territories, or if you're providing advertising or recruiting for that licensure program to that state or territory, you would need to know that your program meets the educational requirements, or if it doesn't meet, you disclose that. And then again, you may have a mechanism for still enrolling a student if they go through that written attestation exception process the department set up. I did want to point out the connection to current SARA policy that exists today. So SARA policy 5.2 is related to licensure, and that's actually connected to the 2020 version of the federal Title IV regulation. So basically the policy is reinforcing that 2020 regulation and saying that all institutions participating in SARA need to follow those requirements. And the policy also adds a couple of things. So it says, if you have a situation where you've not determined if your program meets educational requirements in a particular state or territory, you should first be making all reasonable efforts to make that determination. And then if you still can't determine or it's not determined, you should provide the board contact information with those public disclosures. I will make a quick note that SARA policy modification process is ongoing, and I know there have been some proposals put forth that would modify policy 5.2 and either remove some of these additional things that have been added and simply just reinforce current federal regulation or change it in other ways. So if you're interested in that soon, if not already now, you would be able to review those proposals. And then of course, it'll be working through the policy modification process for the next several months before a final decision may be made if those are taken up. All right, so after public disclosures, then the second piece here around communicating is those individual direct disclosures. Department of Education did not change anything with this section of the regulation. So interestingly here, we do have a mismatch where they're still using not determined in these direct disclosures, even though the department removed it from the public disclosures. But nonetheless, here's where we are. So these direct disclosures, just like you're doing today under the 2020 requirements, will be connected to the student's location. So as I was mentioning before, that will be dictated by your student location policy and related processes that you have set up for your institution. And that could be different institution to institution. If your student location policy dictates that a prospective student or applicant is located in a does not meet or a not determined state or territory, you would need to send them a direct disclosure that lets them know they're located in one of those places prior to initial enrollment in the licensure program. Again, kind of interesting connection here with the other new requirements. These same applicants or prospective students would have to go through that written attestation exception process if you're actually going to enroll them in your program. Because remember, you can only enroll if they're located in a meets state or territory, or if they go through that written attestation exception process. All right, and then the final piece is for current students. Again, this hasn't changed from July 1, 2020. If that student changes location and lets you know about that, again, per your student location policy and processes, or if something changes with the state's requirements or your program's curriculum, and now you have a does not meet scenario, you would need to notify those students within 14 calendar days of the institution becoming aware of that does not meet change. So again, that's the same language, same requirement as we have from July 1, 2020. All right, so many of you may have heard or seen some news that came out last week related to a Department of Ed electronic announcement. So basically what the department has said is they're opening at least a crack here in a window of opportunity for some programs to potentially be able to not fully comply with the new July 1 requirements by July 1, specifically for PPA certification purposes. So what the electronic announcement does is, again, specifies that if your institution is in some sort of unique time-specific scenario that's really outside of your control as an institution, that's preventing you from being able to make a meets determination or does not meet for that you can document what those circumstances are and everything surrounding the work you've done to try to make that meets or does not meet determination. And that documentation could be used as a defense in the event that there's some sort of enforcement action taken between July 1st and January 1st of 2025. So they've kind of, again, carved out this window of time and are really trying to narrow it to if you have very unique time-specific circumstances outside of your control, you could maybe document all that and be able to use that as a successful defense, potentially to any enforcement action. The department has been clear in follow-up emails to myself that this is definitely not a delay in the effective date. It is not a blanket opportunity for institutions to delay their compliance. This is something that would be evaluated on a case-by-case basis should an enforcement action happen and that an institution is trying to use this as a defense to that enforcement action. So again, main point is not a delay in the effective date. July 1 is still the effective date, and probably most institutions are not going to have circumstances that would fit into this outside of the control, very unique, very time specific, but something that you can talk to your council about if you think that that's would apply to your institution so that you can have a process for getting documentation in the works. And again, did want to note that this is only relevant to the new PPA certification section. This would not apply to the public or direct disclosures at all. So keep that in mind too. All right, so we are shifting gears now into question portion of our time together today. I'm going to have Nan help field questions that are coming in the chat. And again, we welcome your questions live. If you would like to ask them on video or audio, you can just raise your hand and we'd be happy to take them that way too.
Chris, no questions in the chat yet, so.
All right.
People are maybe thinking about their questions.
I'll give you all a moment to think if there are questions before we move to something else.
Okay, there's one in the chat from Don. For location determination, should this be written in the financial aid policy and procedures? For example, student's home address will be the location of determination.
Yeah, great question, Don. So there isn't specificity provided by Department of Ed on where or how the policy needs to be created or live at your institution, but it does need to be a formal policy. So if it makes sense to include it within your financial aid policies and procedures, that would be acceptable. I know some institutions may have other ways that they catalog or categorize, different policies that are institutional or university-wide policies. So nothing dictated by Department of Ed on where that has to live, but it should be clear on what the purpose of the policy is and who it's being applied to and when and how it's being applied. And it should be, a formal policy just like any other that is going through your policy modification review processes and all of those things. So keep that in mind. And then as far as the student's home address being the location, that is certainly one viable option and one way that some institutions are setting their student location policy and determination processes. And there are, of course, others as well. So sometimes it's being connected to something other than a home or permanent address. Could be a difference depending on if we're talking about a fully face-to-face on your Nebraska campus in-person program versus an online true distance education program versus some hybrid. So lots of considerations there on how these policies are being set up.
Okay, Chris, we have a question from Ken. How does this apply to a non-licensure program where a student might try to use the program as an alternative pathway to certification in that other state?
Right, that's a great question, Ken. So again, the responsibility under the Title IV regulation is for programs that the institution has designed to lead to a professional license or that you're advertising as that. So if you haven't designed a program to lead to a particular license and you're not advertising it, then it's really not a licensure program, which means it does not fall under these requirements. It's not part of these regulations. So you wouldn't have a responsibility around PPA certification or around disclosures. If you have scenarios where students, are going to try to use something that's not a licensure program to seek a license through an alternative pathway or some other means, the institution isn't responsible for certifying or communicating around that.
Great, I'll move on to the next question, but if you post a question in the chat and I've read it and Chris has answered it and you have a follow-up, please feel free to unmute and follow up yourself if you'd like. But from Brooke, just to be clear, all 59 states and territories do not have to be listed on our site with a determination if we are not enrolling, advertising, or recruiting in those states? Or do they all still have to be listed with meets or does not meet without regard to the enrollment, advertisement, and recruitment?
Right. So this is a great question that we've gotten before as well. And I can understand why, because under the current July 1, 2020 disclosure requirements, institutions are supposed to be disclosing for all 59 US states and territories, either listing it as meets, does not meet, or not determined. Under the July 1, 2024 changes, the department has removed that not determined category from your public disclosures. So really your obligation under Title IV is to disclose where you've determined that the program meets or does not meet the educational requirements. The department has also not placed an affirmative responsibility that all institutions have to determine for all 59 states and territories. In fact, in the commentary that they released with the final version of these regulations in October, they specifically say that we're not requiring all institutions to make a meets determination for all 59 states and territories. What they are requiring is anywhere that you're going to be enrolling students or advertising or recruiting for that licensure program, that you have made that determination. And again, if you're advertising and recruiting, you should know that the program meets the educational requirements, and you can only enroll from a meet state or territory unless that prospective student or applicant goes through that written attestation exception process that's set up.
Okay, great. I'm going to skip to Candace, then go back to Stacy. Candace asks, what constitutes advertising and recruiting? For example, would our college website constitute advertising or recruiting?
Great question again here, Candace. So unfortunately, we do not have specifics from Department of Ed on what they would consider advertising or recruiting. It is possible that we'll get some more information about this from Department of Ed when they release an anticipated question and answer guidance document. I was hoping it was coming out this week. When I checked earlier today, it still hadn't. So look for that next week, hopefully, where we will have some written Q&As from Department of Ed, and I suspect maybe one or more of those will touch on this advertising and recruiting. But with that in mind, I think that the idea here is related to that specific licensure program. So in, again, some email exchanges that I've had with department staff, it doesn't seem like their intention is to prevent an institution from advertising online or otherwise broadly, right? So advertising your institution or advertising other programs. It's really about that particular licensure program that does not meet educational requirements. So that it doesn't meet, you would need to try to restrict that advertising for that particular program. And I don't know how all of these things work with online advertising. I'm sure there probably are some mechanisms to restrict who's seeing what kind of ads on social media or on search engines or other places. But I also know that it's probably challenging sometimes on limiting exactly who's seeing what. So the realities of what is possible to limit would also, I'm sure, come into play here when you're thinking about what might need to change as far as any online kind of advertising that you're doing.
Okay, thanks, Chris. Stacy asks, where can you find the state's minimum educational requirement for licensure to determine if you need to adjust program length, since there's a new limit on program length that is to be 100% equal?
Right. So I didn't touch on this yet at all. Stacy and others, you may have noticed. There are other new changes coming for July 1st for a lot of different things. And one of them is about this program length, and it's for gainful employment programs specifically. So this would not be applicable to some of your institutions. In fact, if you're offering an associate's, sorry, now that I'm saying that, I'm questioning myself. I know for sure it's bachelor's and above, but I think it's associate's level or above degree program that it's not beholden to this 100% length. And then the other factor is for gainful employment. Typically that only applies to for-profit institutions, or if you're a nonprofit institution that's offering something less than a degree. So again, something less than an associate's degree, like a certificate or something like that, those could be considered gainful employment programs. So all of that was setting this up. Where do you find the minimum educational requirements? So this is actually the same process that you would use to find educational requirements for any license that you're trying to research in order to compare your program's curriculum to. And you do need to start with the state or territory's law. So you'll need to look at their statutes and regulations, rules. Every state and territory gets to set their own requirements for what needs to be included in that person's education in order to qualify. And sometimes it will be very detailed, like a listing of classes that they're going to be looking for on a transcript. Even sometimes more granular than that, like looking for particular content measured in clock hours. And so they're going to dig into the syllabi for courses and want to see assignments in very specific areas. So you find it in the law. That's where the details are typically. You can also utilize information on the licensing board and agency's websites. Often the websites will have a link to the law for you. So you go to the, whatever board for that state or territory, you can find a link to their statutes and rules right there. It'll kind of get you pointed in the right direction to start with. And another good source is like national associations for these professions or occupations, or there are even associations of the licensing boards themselves at a national level. And sometimes those associations or groups have good information, at least in some facets for what those educational requirements are. We haven't found anything that's that includes all of the educational requirements. There are some that are getting very close, like the Marriage and Family Therapy Association of Marriage and Family Therapy Boards has really good detailed information. So does National Council of State Boards of Nursing has some pretty detailed information for nursing related licenses too.
No question in the chat. Candace had a clarification she thought on gainful employment. And if anyone wants to ask a question by raising your hand or getting off mute, please do.
I'll pause just another minute here in case you do have other questions before we shift gears into some discussion. So get those discussion caps on, if you would, because I think it would be useful to dig into some of these areas a little bit further together. All right, we can always come back to questions, of course, too. So if you have something as we start digging in here, we can circle back to questions. But before we get to discussion, we wanted to start with a poll. So if you haven't used a Slido before, two ways to do it. You can use your phone and scan that QR code that's up here on the slide, and it'll take you to the Slido poll where you can answer it right on your phone, or you can go to slido.com on your laptop or other device and then punch in number 2561206. And if you'd be so kind as to participate in the poll, we'll get the live poll on the screen here in a moment. We'll be able to see everyone's results as they are coming in. So again, you can scan that QR code or go to slido.com and put in 2561206.
Uh-oh. Oh, I have to do the link.
Yeah, click on that
got,
present link. There you go, man.
I was going to say, what happened?
Great. Thank you. So we've got some results coming in here. What are the biggest challenges with implementing these regulations at your institution or institutions you work with? Looks like the leader so far is researching the educational requirements in other states and territories. Definitely a very time consuming, involved, heavy lift kind of work there. So that makes sense and tracks with what we hear from other states as well. Comparing your programs to those state and territory requirements, also a challenge. Integrating the requirements into your admission and enrollment process can be difficult as well. Looks like there's pretty good support from your leadership, which is great to see. Sometimes we hear from institutions that there are challenges with getting the needed necessary resources and support to engage in this work. So I'm glad to see that's not a big challenge for most of you in Nebraska. All right, so I think we're pretty close to most all participants. Thank you for participating there. Researching those educational requirements is the biggest challenge. So if Nan, if you want to go to the discussion questions, I'm going to do these probably out of order because I would love to hear if anyone's willing to share how you've set up that process at your institution for researching the educational requirements. Are you having staff do it? Are you doing it yourself as a compliance person? Do you have faculty assigned to do it? Something else entirely? I think we may have one institution participating that uses our services. We offer an online database called the Bookmark that includes educational requirements. So is anyone willing to share how you're tackling that research challenge or how you plan to tackle it if you haven't started already? Michael, go ahead.
Thanks, Chris. I'll go ahead and just chat a little bit about this. I know that the university system we currently have an academic compliance working group that's working through some of these major questions with representation from each of our campuses, specifically to identify some of the definitions to try to come up with definitions that are similar across the system, as well as some IT solutions that may be beneficial across our campuses since we utilize similar student information systems, things of that nature. As far as the program research is concerned, that is up to the programs themselves to complete. And that actually came out of work that was done back in 2019 when the licensure notification procedures initially came into being in July 2020. We established that. So that my understanding is that campus programs themselves are doing that state-by-state research, depending upon where students are located for their programs. That's kind of what we're doing with right now. It's a big lift, and we have a lot of people that are part of that working group, and sometimes that can take a lot longer to complete, to try to integrate what 4 campuses are doing as opposed to perhaps what an individual campus might be doing. But we're moving forward as best that we can.
Great, thanks for sharing that, Michael. Do you or does somebody on more of your team kind of run at like a project management role for that, or how are you keeping all those trains running from all the different campuses and programs?
That's what my responsibility is to try to encourage that collaboration across campuses and act as a facilitator for that working group, to try to ensure that the campuses have the latest information related to the regulations, anything that comes out from the department or from NC SARA or any of our other national partners like WCET SAN or others that might have relevant information that's beneficial to the campuses. I help to facilitate getting that information out to the campuses and the relevant individuals on our campuses.
Not a minor thing. Just keeping everyone informed and coordinating is very much a lot of work as well in and of itself. So I think I saw in the chat we had a couple other folks weigh in that it sounds like maybe a similar approach that program directors or leadership within the programs themselves are responsible for doing the research on each state's requirements. Great. If anyone has anything else you wanted to add, feel free to do that before I am going to ask another question, if you'd be so willing. I'm curious, what point in time has your institution set as initial enrollment? So this is relevant in a couple of different ways to this work, but really for that new PPA certification requirement, again, the responsibility is that you're able to certify that your program meets the educational requirements where that student is located at the time of initial enrollment into the licensure program. And the department hasn't defined or dictated what that exact time needs to be. We have some guidance again from commentary from the 2020 regs as well as these new 2024 regs, where it should be at some point in time prior to a significant financial commitment by the student. But that's a pretty big window of time, right? From when they're inquiring about a program and applying and then being admitted and classes start. So a big window of time potentially here. Does anyone want to share how you're thinking about initial enrollment, or if you've even set that into a policy or anything at this point? Thanks. Christy put in the chat here, we use the first day of class, but we will be communicating with out-of-state students in those does not meet locations long before the first day of class in the admissions process. I think that's a key point you bring up, Christy, is if you are using first day of class, you want to make sure that you are not setting up students to be surprised when they're located in a does not meet place and you essentially can't enroll them or have to put them through that written attestation exception at that point. So a good idea to make sure you're doing some disclosures and communicating long before that point in time. Anybody else approaching that the same way, where you're going to set initial enrollment as that first day of class?
Michael is volunteering again. Thank you, Michael.
I was just going to say that's one of the main questions that we have of our working group. We have a meeting actually Monday to discuss that specifically. I am curious to hear from you and others. I have some colleagues in other institutions and systems outside of the state that are really looking to use the time that the offer letter is sent to a student as the initial time of enrollment, because that occurs well before a student, even if they're traveling to the campus, before they make any kind of commitments for housing or anything like that. And is there a concern that moving that date of initial enrollment much further back in the process creates some unintended consequences?
Yeah, I think I know where your head's at with this, Michael, right? So if you've got scenarios where a prospective student or an applicant's coming from outside of Nebraska, they're going to be coming to a campus-based, face-to-face program, but your time of initial enrollment is set at wherever they're physically located, whatever their address is in your system that you're sending that letter to, right? So that's probably going to be going out of state in this scenario if that person is relocating to Nebraska. I think it could have unintended consequences. So if your student location policy doesn't have anything else where you're treating campus-based face-to-face students in a different way, then the default would be that they are located wherever you're mailing that letter to, which again means you'd have to be able to certify that your program meets that state's educational requirements or put them through that written attestation exception process.
Michael, this is Christy. I'm wondering if maybe you're thinking about our friend in Colorado, who I was at San Advanced with. And at the time, they were thinking about time of initial enrollment, just because that's what, their systems are all set up around. And I think what we'll do is keep it that way because that's what our systems are set up around. But really, that's the last point in time where you can probably do something with the student. We're going to have early on in the process, really treating them like we need to get them prepared to come to campus. So they'll apply, we'll know their location, and then we'll do that attestation part of it. If they plan to stay in that location, we'll do that attestation early on in the admission process. So then when they arrive on their first day of enrollment on our campus, if we get to the first day enrollment and they're at that other location, we'll have the attestation on file and they could just keep doing class. So that's kind of what I'm thinking, but I wondered if maybe, again, have people been rethinking that for any particular reason?
Well, I think that's what one of the questions that's come up is that if you get an attestation well before your campus's official initial, first day of enrollment, does that attestation count according to the Department of Ed? Because the regulation specifies at the time of initial enrollment. And so if we have it ahead of time, is that okay? Or does it have to be done at that time? That's kind of what I think maybe we're really digging way too deep into the regulations itself. And really, in thinking about what is the spirit of the regulation, we really want to make sure that anybody who is located out of state, who wants to take programs at our institution, that's going to be a distance education student, we just want to know, are they going to be in their state, and whether or not we meet those requirements. And if not, I'm sorry, we can't enroll you. Or if they're going to be coming to our campus, or if they're going to attest to that they're going to be seeking employment in a state where we do meet requirements. And at what point, if we get that information earlier on in the process, I think that serves students much better. I just don't want us to kind of run afoul of what the regulations might state if we're doing something way ahead of time.
Mm-hmm. Yeah, that's a great point, Michael. I think I haven't yet talked to anyone thinking through that, like basically, could we do the written attestation too early? So I understand your thoughts on where you're going with that. I think the important part of the written attestation, though, is that the student is attesting to where they want to seek licensure and employment after they complete your program, right? Like that's kind of the key, that's the crux of the attestation itself. And so if that piece is still really clear, these are probably bad assumptions I shouldn't be making, but I would think, many students would know as soon as they're inquiring about your program, right? Like they're going to know as much as they can know what their plans are, if they're going to stay in the other state where they're currently located, if they'll be moving to Nebraska on your campus. And ultimately, they're going to know what their plan is for after completing the program, if they're going to be licensed in Nebraska or not. Again, I know these are big assumptions and this doesn't always work in the real world because a lot of students have no idea. They could be military affiliated and be assigned to wherever. But unfortunately, Department of Ed has not put anything in place to account for those scenarios where students truly do not and cannot know where they're going to be at the completion of a program. So you have to kind of ignore those for these purposes, I think, thinking through the scenarios. But as long as that written attestation is clear about where they're going to seek a license and employment after they complete the program, I would think that is the main thing the department's concerned about, not necessarily exactly when they provided you that attestation, as long as it's done before initial enrollment, whatever you set that as.
I think that that's what's one of the concerns is that as a system that has multiple campuses that, I mean, we're all very military student friendly, for example, and, you know, a military student or their spouse, you know, they're not going to know presumably in 2 or 3 or 4 years where they may be. And there's no provision in the attestation to say, I'm not interested in seeking licensure at all, but this is the program that I want to take. If it's a licensure program and they're located in a state where we don't meet the requirements, we cannot enroll them, period. And so I think that this is going to adversely affect many distance education programs unintentionally, and it really limits student choice. But I mean, all of these were arguments that we'll be making in public comments and things of that nature with the hopes of modifying the department's policies. But you know, this stuff right now, this is what's going into effect. And so we have to deal with these regulations as they stand now. So yeah, those are kind of some of the issues I think that our campuses are bringing up as to, are we going to see a 20% drop in enrollment because we have 20% military students in our program?
Yeah, that's very, very real. You know, I absolutely everything you said is correct. And unfortunately, again, you know, Department of Ed did not understand or consider the impacts here, especially to the military affiliated students. And it could always change, right? Like we can be optimistic that once this rolls out, like the department will realize, oh, this is not a good idea. And they could, you know, release some guidance or something pretty quickly to modify the written attestation expectations that they've set up at the moment. So let's see.
Chris, I would imagine that you might suggest that their location policy includes some of these items. The process of gaining attestation prior to maybe the first day of start of class, but addresses, you know, try and lay that all out in the policy.
I definitely need to have it documented for sure. And I would say, yes, some of you may want to include at least a portion of those details in the policy itself. Again, I know that the different institutions approach your official policies, you know, in different way. So it may not make sense to have all of the process details in the policy itself, but there could be a related, you know, process document that references the policy, whatever it is. But man, thanks. You bring up a good point. Documentation is critical for all of this work. And so that could be our next discussion question, actually. Have any of you set up a process for where you are and how you are documenting your like decisions around these things and like moving forward, what the processes will be? And then also, how are you documenting making those meets determinations? So have you set up some sort of repository where you're going to be storing anything related to this work? Maybe you haven't thought about that yet and will want to consider that in the future. Anyone have anything they want to share about documentation?
While you're thinking about that, I'll mention that Ken did put in the chat that they're looking at initial enrollment as a process, considering a ready to enroll stage in the admissions process, but then moving to reportable enrollment by numbers after the term census date. So again, with that and others, how do you intend to document? Making sure you have process and policy in place, how you make determinations. What is your thinking on that? I think, Chris, you mentioned in one of these discussions that hopefully it's not an email solely confined, documentation solely confined to someone's email, because if that person leaves, you might lose that.
Yes. Yep. Right. Like any compliance related thing, not a great idea to rely on one person to individually be your keeper of information around this stuff. So to have something set up. I see Christy put in the chat here that they rely on program directors to keep documentation of how their decisions were made. So that can make sense if you're having them do the comparisons and making those determinations. It might be a good idea to have, again, some sort of more centralized like table of contents of sort or something so that you don't have the documentation only living, on one individual program director's drive or folder or something. So in the event that there would be an audit, Department of Ed could ask you to produce documentation and evidence on how you actually determined that your counselor program meets the licensed professional counselor requirements somewhere. Yeah, and of course, shared drives, great idea. One thing too, if you're thinking about documentation, so certainly any kind of communication that your program directors or whoever's doing the research and comparison, any communication with a board, licensing board or agency, get that in writing if at all possible. So get an email, and then you'd want to retain that again somewhere outside of that individual person's email folders or accounts, but retain copies of any of those email communications that your program directors or whoever's doing that research and curriculum comparison is having with boards if they are. All right, I'll throw out another question here. We touched a little bit about public disclosures earlier, some of those changes that are coming with the July 1, 2024 version. So have any of you already started to update your public disclosures on your website? Maybe removing that not determined category, or are any of you thinking that you're going to keep the not determined category up on your public disclosures? Kind of how are you approaching public disclosures starting this July 1?
Hi, Chris, it's Christy. We have updated our website. We've decided not to use have not determined. We're doing yes or no. Sometimes no means we didn't have enough information, but we're just going to go conservatively with a no. We don't thankfully have many no's, but that's how we went. And we decided to make determinations on all states and territories. We have a limited number of licensure programs. I don't have to manage nearly the volume that Michael does, for example, but that's what we've done.
Great, thanks for sharing, Christy. Anybody else have thoughts on how you're going to tackle public disclosures? Are you going to change anything? Are you going to keep those not determines up on your public disclosure site?
Chris and I appreciate that MEC wanted to host these sessions, and they really wanted it to be for each state. so you could hear each other too. So that's why our format is not just to present to you, but really encourage discussion among you. I also know it's early afternoon here anyway, so maybe a little difficult, or maybe you collaborate often and you're already up to speed. But that's the reasoning behind this format. We also want to make sure that we answer any questions you have that we can. Sarah has her hand up. Sarah.
Thanks, Nan. In a couple of the other meetings, I think Chris had mentioned some kind of, I know you've already talked about documentation and the importance of it, but I think Chris, had you mentioned something about Ms. Is it Cortez had been quite responsive to your questions and provided you some written confirmation or guidance?
Right. Thanks, Sarah. Yeah. So Vanessa Gomez is the individual's name who is the U.S. Department of Ed staff person that was assigned to field questions about this particular regulation change. So anyone can send Ms. Gomez an email and with any questions you want to about these changes. And she has been responsive. I know she's also been responsive to many other people who have been submitting questions to her. I actually had some open questions out to her, but I know she was actually out of the office for about a week and a half, I think, lately. So waiting to hear back on a couple of things. But yes, so if there are things that your institution is still trying to wrap your arms around and you think that Department of Ed could help clarify, feel free to reach out to Vanessa Gomez. I don't think I have her contact information on a slide, unfortunately. Sorry, you may be able to grab that and put it in the chat. But otherwise, we can certainly get that to folks if you can't find it yourself. Her name and email are listed clearly on any of the Department of Ed's websites announcing this regulation change, and then also where they have the actual language from the regulation. You can see her name and email there as well. But it's vanessa.gomez, and then whatever their whatever the ending at US whatever it is, .gov. So
I'm looking for it so I can post it.
thanks, Nan.
Yep.
And thank you, Chris and Nan, for working and helping us bridge that communication. Sometimes we need answers that for some reason we aren't able to get, and it's through your determination you help us get those. So thank you so much for being that bridge.
Yeah, of course. And we, again, will continue asking questions. I mentioned the question and answer guidance document the Department of Ed is planning to put out. Nan and I were at the NASAPS conference last week, and there was another Department of Ed staff person there, Leslie Whistle, who announced that they would be publishing this Q&A very soon. So again, we're hoping that that's going to come out next week. If not, maybe even still yet later today. They have been known to drop things at the end of a Friday afternoon from time to time. So could get that, have some weekend reading to do if they do that. So. All right, well, we do have another poll question. I think, Nan, we could probably go ahead and hang on one second though. I just realized I forgot to do something here. I got to flip over the poll question so you don't see the same one again on the back end. All right, now we're ready to go. So if you would like to participate in this one, you again scan the QR code, or you could go to slido.com 2561-206. And this one we have you able to put in a couple of words or a short phrase on, what's your first order of business related to this work. So what are you feeling like is your priority for your institution? If you want to share that through slido.com 2561-206. We'll present those here. It's going to come up like a word cloud response. See if we have some common answers from some of you.
And if you haven't yet gotten the code. It's on this screen as well.
It's like policy is top order of business there. Makes sense. That student location policy is even more critical for these changes for July 1. Getting the correct people at the table to discuss also is super important, right? So I think every institution we talk to from any state, I mean, this is always some sort of collaborative effort. Just the sheer amount of work, it's impossible for one person to do this all. And then when you're talking about programs that span across, multiple schools or multiple parts of an institution, it's really important to have all those players involved along with your IT and financial aid team. So the program participation agreement is something that your financial aid team, I'm sure, is very familiar with. There's probably one person whose job it is to stay up to date on PPA changes and be ready, to sign those or attest to those when the time comes. So make sure that your financial aid folks are aware of this new PPA certification responsibility also, and what your processes are in making those needs determinations, or what the processes are around enrollment and admission, to stop those folks from being enrolled or admitted that their aim does not meet places.
Chris, Don is asking, I know I'm not, are you presenting at NASFAA?
No, I am not. Donna, I'm kind of remembering that possibly Cheryl Dowd from WCET SAN, maybe, but I'm not 100% sure. I know Cheryl's been trying to connect with some of those other, national associations and groups that are impacted by this, but may not know a whole lot about it yet, at least not as much as many of you that are kind of in the state authorization or other institutional compliance spaces do. Great. Well, a lot of great business to get to here for this work.
I have not found Vanessa's, I can't believe how many different slide decks I'm going through here. Here, I found it. Okay, so it'll show up in the chat in just a moment.
Thanks, Nan. And I think we maybe just had one other slide that I might have had you skip over, but I did reference it before. Part of what we do is work with institutions to help support their compliance efforts. So if any of you would be interested in more information about the services we offer or the Bookmark, which is our online database of education requirements, feel free to reach out. We, of course, would be happy to share that information with you. And thank you, Sarah. I know you had already put in the chat, we're doing an upcoming webinar for MEC on April 30th. This favorite topic of ours, but it is a two-part session. And the first part is specifically geared towards institutional leaders. So if you have, and again, there were just a few of you probably that answered, you were having some challenges getting support from leadership, might be a good one to try to invite them to, so that they can hear about this directly and be able to ask questions should they have it.
And just as a reminder, this session has been recorded, and it will be uploaded to our MEC website along with the slides post-event. Most likely it will be Monday before our communications director can get to it, but I promise it will be up there. And once it is, a link will go out as well as the attached slides. So again, Chris, Nan, thank you so much for helping us navigate such a interesting, for lack of a better word, on a Friday afternoon, regulations. So thank you for all your hard work and for keeping up to date on all of these changes. We really appreciate your expertise.
Well, happy to be here. Thank you all. Again, don't hesitate to reach out to us if you do have questions in the future, if there's anything we could do. So take care.
Thank
Thank
you.
you. 15 minutes back on a Friday. Yay!
Yay.